Thank you, Mr. Chair. Mr. Cole, am I correct that it's your position and position of everyone on the panel that the telephone records of potentially hundreds of millions of Americans in the form of metadata, as has been discussed today, is relevant to a national security investigation?
They are relevant when they are only queried under the limitations that are described by the court, where you have to have reasonable, articulable suspicion that it's connected to some terrorist matter and investigation.
So fundamentally, it's your position that they're relevant because the court, the FISA court, has articulated a set of criteria by which further inquiry can be undertaken. Is that correct?
They are, and they're relevant because you have to have it's the old adage of if you're looking for the needle in the haystack, you have to have the entire haystack to look through, but we're not allowed to look through that haystack willy-nilly.
Right. Now, in terms of looking through that haystack of these phone records that are acquired, based on reasonable, articulable suspicion, am I correct that it's 22 NSA individuals who are authorized to make the determination of reasonable, articulable suspicion? Is that right?
I'll give that to Mr. Inglis to give you the numbers.
That is correct, sir.
Okay. So these individuals don't have to go back to the court in order to determine whether they can move forward with a more invasive inspection of the phone records of the Americans contained in the database that you've acquired. Is that correct?
They use the rules of the court to make the limited query that the court...
Right. They're using the rules of the court, but they're making the determination, not the court, as to the invasiveness of the further inspection. Am I correct?
On a case-by-case basis, they determine the selector.
Okay. Now, Mr. Litt, you've indicated that, in your view, the FISA court is not a rubber stamp, correct? That was your testimony?
That's correct.
And I think in response to the distinguished gentleman from Idaho, you said, well, it's not a rubber stamp because they read, they ask questions, they push back, there's careful study and analysis. Is that an accurate characterization of your testimony?
It's reasonably accurate, yes, sir.
Okay. Now, we just had a baseball all-star game yesterday, and, of course, we know, nothing is as American as baseball and apple pie. And if you think back on the history of baseball, I just took a quick look. I'm a baseball fan myself. Now, Stan the Man Musial, great hitter from St. Louis, his batting average lifetime, he was close to being in the top 25, 331, Stan the Man Musial. Babe Ruth, 10th all-time. His lifetime batting average was 342. Ted Williams, the great lefty from the Boston Red Sox, his lifetime batting average was 344. Ty Cobb, the Georgia Peach, I may disagree with some of his views on social justice issues, but he was a great hitter. The #1 hitter all time.
363?
Based on average. 366. Pretty impressive, though. But I'm still going to continue to ask you questions about this dynamic. Now, I took a look. So these are the greatest hitters of all time. I took a look at what your batting average is as it relates to the FISA court. And I'm a little troubled at what we were able to determine. So am I correct that in terms of the total applications submitted since 1979, there were 33,949 applications submitted? Is that accurate?
I don't know the number. I wouldn't disagree with your number. I just don't know it off the top of my head.
And of that total number of applications, 490, it appears, were modified. Is that correct? You have no reason to disagree with that number. Is that right?
I don't know the answer.
Okay.
But if I can just add one.
Well, let me just make an observation.
Okay.
I've got limited time here. 1.4% of the total number of applications made were modified. But what's even more troubling, since 1979, 11 applications were denied. Is that correct? 11.
Again, I'll take your word for that.
Okay, so your success rate, your batting average, was 99% of the time that you've applied to acquire information that could possibly include communication from one American to another American. Yet, you've taken the position that the FISA court is an independent check to protect the civil liberties and constitutional rights of Americans. Is that correct?
So I guess the answer is that we're not exactly talking about baseball here. We have a situation. If you imagine a situation where the kind of interaction we have with the FISA court is the FISA court throws a pitch and we don't hit it, and we say the court says we want the pitch a little bit higher. Can you throw the pitch a little bit higher? And it's still not right to make it a little more inside. That's the interaction we have with the FISA court. They come back to us and tell us what we need to do to submit an application that will get approved.
Right. Those modifications, and I know my time has run out, only took place 1.4% of the times, and that's why I think we're all concerned, or many of us are concerned, that there's not an appropriate check on behalf of the Americans whose records could be subjected to an invasive search. I thank you all for your service. Yield back the balance of my time.
May I say one thing briefly,
Sure.
Mr. Chairman? The number for modification there, I think, does not reflect the full number of times in which the court asks questions and comes back to us. My understanding is that comes at the very end of the process, but there's a substantial give and take before we get to that point. So that's not a full reflection.